Thank you.
That's 8-0. Your bill is out.
Thank you. And next is file item 1190.
Please proceed.
Another unanimous vote, I expect. This is a measure dealing with the Coastal Commission. The firing of the executive director of the Coastal Commission has resulted in a high degree of public uncertainty and concern, with accusations of a lack of transparency in the decision-making process and concerns of undue political influence by commissioners in dealing with commission staff. SB 1190 is designed to help restore the public's trust in the commission, to ensure that decisions made by the Commission are more transparent and remove backroom decision-making or the public perception of backroom decision-making, both of which I think we all agree are important to the integrity of the state and the work that government does. SB 1190 will restore this confidence by codifying the independence of Commission staff and banning ex parte communications in certain circumstances. Recent technical amendments provided by the Coastal Commission narrow the scope of the ban to apply only to quasi-judicial matters, which are defined in the Public Resource Code, Section 30,321, and enforcement proceedings at the Commission. So the Commission has responsibilities that are both judicial, making decision-making, and quasi-legislative, for which ex parte communications, as we do here, are appropriate. But if you think of quasi-judicial as being what would come before a court, and the efforts that we make to have transparency in our court proceedings, that is the analogy I would draw here. I would also draw the analogy to the fact that the Public Utility Commission is prohibited from ex parte communications in its quasi-judicial function as well. And as many of us who've had lots of free time today know that the governor came out with an announcement today supported by a number of legislators trying to restructure the PUC, that the governor again affirmed the importance of maintaining the prohibition on ex parte communications in that body in areas affecting quasi-judicial proceedings. So these amendments that the Coastal Commission assisted us with bring the policy on ex parte communications at the Commission in line with court decisions as well that have found ex parte communications on adjudicative matters to be a violation of procedural due process. An example of why ex parte communications are problematic was recently brought to light by the Los Angeles Times, which many of you may know has been eyeballing this issue with great interest and fervor over the last many months. The LA Times reported that the chair of the Coastal Commission conducted an ex parte communication with an applicant and then sent an email to Commission staff urging them to change the contents of their report based upon that communication. The other side had absolutely no ability to make their case on the issue, which is why when we have adjudicatory proceedings, we allow, encourage, and require both sides be given an opportunity to be heard so that the decider, the decision maker, the decision-making body has all the information before it necessary to make a decision. And this kind of influence of one side having an opportunity to communicate, make its case, and then see that commissioner propose changes without any opportunity to respond has been troubling, because the Coastal Commission is a state agency. It's not a planning body. And unlike other bodies that have staff working for elected officials, rather, Commission staff works for the people of California. The Coastal Commission, granted, is a bit of a hybrid because it was created as a result of an initiative back in the early 70s that was promulgated by the people of this state, saying the coast of California belongs to all of us. It was an initiative that passed somewhat overwhelmingly, if I'm not mistaken, and the Coastal Act was then created to try to address and respond, to be responsive to this initiative proceeding. So the responsibility of the staff is to report and represent the will of the people. Now, the Commission carries out and enforces the Coastal Act, so it's critical that the staff reports from which decisions are made, those staff reports are independent, scientific, and legal analysis that interpret how state law applies to a specific proposed project. By banning ex parte communications for these adjudicatory and enforcement proceedings, this measure will reestablish due process and fairness at the Commission. It's important to note that SB 1190 will not stop commissioners from being able to ask questions and disagree with staff findings and recommendations. It just requires that the disagreement take place in the context of a public hearing, similar to what happens in a courtroom. The arguments are made in public, or if they're not and there's some just cause, there is a court reporter in a courtroom where these proceedings are still advanced so that both sides are heard, and ultimately, usually, almost always actually, the public is then part of the process, or at the very least understands and knows what those discussions were. So it just requires that this agreement be in the context of a public hearing. Commissioners are still able to express their own views and vote as they see fit. This, I believe, is a good governance bill. It's actually supported by the Coastal Commission itself, that will align the Commission with other boards and commissions that do not permit ex parte communications on quasi-judicial matters. And as I mentioned just today, that was reaffirmed by the Governor in the work that's being done to modify, modernize, oversee, correct, whatever one wants to characterize the problems with the California Public Utilities Commission. In fact, SB 1190 only gets the Coastal Commission to the same place the PUC has been prior to any of the reforms that were just signaled by the Governor. And with that, I would respectfully ask for your aye vote.
Witnesses in this committee have 2 minutes each, so please proceed.
My name is Sarah Wan. I'm representing the Western Alliance for Nature, and let me give you a short background so you understand why I think this is an incredibly important bill. In the 80s and 90s, I was a coastal activist who regularly appeared at Commission hearings. In 96, I was appointed to Commission and served as a commissioner for almost 15 years. And since then, I've been a paid agent representing clients at the Commission, doing ex partes on their behalf. I know this from every side, and I can assure you nothing is fair about the current process. Not only does it inherently create bias, but there is no way for the public to compete with paid professional agents. This bill goes a long way towards removing that bias and restoring due process and transparency. The Commission is a primarily quasi-judicial body. Commissioners are supposed to go into a hearing and act as judges to determine if the development proposed is consistent with the Coastal Act, not with any preconceived ideas based on closed-door meetings. The current ex parte situation is totally one-sided. Even when activists occasionally get an opportunity to speak with some commissioners, they cannot usually meet in person, can't go to every meeting or socialize with commissioners, and they are therefore at a disadvantage. This bill will restore due process and transparency in government. And by way, in addition, take one look at the ex parte forms that are filed, and they tell you that they're not adequate. They simply don't tell you what went on in those meetings. This is not about preventing development. This is about upholding existing law. No matter what some would have you believe, almost all development eventually gets approved because the Coastal Act does not prevent development. It simply requires it be consistent with the state's long-term objective of sustainability. If no one can talk to commissioners in advance, it does not mean that there will not be input from all sides. It is that the input must be in writing and available for all to read. Commissioners will then come to the hearing with an open mind, read the staff report and correspondence from both sides, listen to the testimony, and then do their job as judges and determine whether or not the permit is consistent with the Coastal Act. I might add that no other commissions allow ex parte for adjudicative matters. So the Coastal Commission is actually an exception in this matter.
Thank you, Sarah.
This bill will place greater emphasis on and meaning to the public hearing.
Thank you.
Good afternoon, Chair and members. Sarah Christie, Legislative Director for the California Coastal Commission. I think that in addition to the fact that the Commission has voted to support this bill, the most important thing that I can impart to you today is that in my research supporting the Commission's position, I went back and read the bill files from 1992 of the bill that originally amended the Coastal Act to address ex parte communications, and I was gobsmacked, quite honestly, to see that every single document in those files, from the author's floor statement to all 4 committee analyses to the signing letter to Governor Wilson and the support letters from the NGOs, that everybody involved in the process expected that AB 3459 was going to prohibit ex partes, but require their disclosure should an ex parte take place inadvertently. That essentially tracks what's existing in the Administrative Procedures Act, and that's how the bill was intended to be implemented. But quite obviously, over time, the focus has been on the disclosure part and less on the prohibition part. And as a result, we have the situation that's before you today. As the previous witness said, the Commission is nearly unique among state agencies. It allows ex parte for quasi-adjudicative matters. The BOE also allows it, but they're a directly elected board. Again, just to restate the previous witness, this does not quell the amount of information and communication that can take place with commissioners. It just requires that it take place at a public hearing so that everyone has equal access to the information. Happy to answer any questions you may have. Thank you.
Thank you. Other witnesses in support? Please state your name, affiliation, and support.
Amy Trainer with the California Coastal Protection Network in strong support.
Marcela Gutierrez Graudin, Chula Sur, strong support.
Jenna Price with the California League of Conservation Voters in support.
Julie Snyder with Planning and Conservation League in support.
Kyle Jones with Sierra Club California in support.
Juan Altamirano, Adwan, California in support.
Angel Fong from Environment California supports.
Vern Gehring with the California Native Plant Society in support.
Rico Mastrodonato, Trust for Public Land in support.
Witnesses in opposition? You have 2 minutes each. Please proceed.
I'll go first. Sure. Excuse me. Good afternoon. Stanley Lamport, California Business Properties Association. I'm a land use lawyer, and I also have a civil trial practice. I've been practicing in front of the Coastal Commission for over 20 years. I represent community groups. I represent applicants. I'm on both sides of issues in front of the Coastal Commission. And I can tell you that a Coastal Commission decision is not a trial, and a quasi-adjudicatory process is everything that the Coastal Commission decides, that whether it's an LCP certification, whether it's a coastal development permit, whether it is it's an enforcement proceeding. When I litigate those in court, the standard of reviews is quasi-judicial, quasi-adjudicatory standards. It's the same throughout. This is, as I said, not a trial. And the big issue is this. When you get in front of a Coastal Commission hearing, they meet 3 days, maybe 4 days, 1 week a month. You get a staff report that comes out maybe 2 weeks if you're lucky in the first mailing. It can be hundreds of pages long. People get maybe a week to present an opposition. And then you get in front of a hearing where if it's a substantial issue, you get 3 minutes. If it's an enforcement proceeding, you're lucky if you get 10. If it's a permit, maybe you get 15 or 20. It takes an entire semester to sit for a 3-hour exam. And sit down and think that a commission can sit with that kind of information on a 3-day agenda where every staff report looks like that and be able to process that information and hear it doesn't work. Ex partes is an opportunity to sit down with a commissioner when you have this crushing out of information in the limited amount of time that you have and assemble that information in a way that you can have a meaningful discussion in the few minutes that you have in a hearing. And that's why ex partes are important. Just as 2 minutes in a hearing room like this is a very difficult way to cover all of the substantive issues that this legislation addresses, and why you take meetings with various interested representatives so you can formulate an understanding of the issue when you come down to this 2-minute presentation, so too it is important in front of the Coastal Commission. These are land use decisions. They are no different than the kind of land use decisions that you see from a city council or a planning commission, and they are intensely local. And the only other thing I want to add is there's a big concern with respect to A2 because it bans any kind of communication, written or oral, by an interested person with respect to an enforcement proceeding, but it doesn't say to whom. So theoretically, if I represent somebody in connection with an enforcement proceeding, I can't communicate with neighbors to organize them or speak to the press because there's nothing in the bill that focuses to whom the prohibition applies. This is a poorly conceived idea to fix a problem.
Mr. Chair, members of the committee, my name is Steve Assetti. I'm the Executive Director of the California Coastal Coalition. We were formed in 1998. We're 35 coastal cities and 5 counties, Sandag and other regional agencies. This is the first time that I've found myself in the position of opposing one of Senator Jackson's bills, but I do it for the following reasons. The Coastal Commission is one of the most powerful regulatory agencies in the country, so any legislation that affects the way it operates should undergo strict scrutiny. I applaud the author for trying to increase transparency in the way the Commission operates, especially in view of recent developments, but existing laws and regs regarding ex parte communications and reporting requirements would render this bill moot if they were more consistently enforced by the Commission staff and followed more closely by the commissioners. In addition, there was no mandate from the Commission for this bill. It was a 6-5 vote. It could have easily gone the other way. SB 1190 and the companion bill, AB 2002, grew out of the hysteria that followed the firing of the Coastal Commission's executive director amid charges from NGOs and the public that there was a lack of information about how and why the executive director was fired. The press irresponsibly alleged that the firing was due to trying to load the Commission with pro-development people, and it was very irresponsible reporting because if the reporters had read the Coastal Act, they would know that right now there are sufficient safeguards in the Coastal Act to ensure transparency. The bill also raises issues of due process. If only staff are able to discuss applications with commissioners before an applicant's hearing. Banning a commissioner from not using his or her official position to place undue influence on staff is vague and would be unenforceable. Who is going to decide what undue influence is left unanswered in the bill.
Thank you, Steve.
So just to sum up, there are existing laws, existing regs that need to be enforced, very specific reporting requirements from Assemblymember Stone's bill last year, AB 474. We need to follow what's in the law.
Thank you, Steve. We got it.
Okay.
Other witnesses in opposition, please state your name, organization, and in opposition.
Valerie Nero for the California Chamber of Commerce. We're in opposition.
Randall Friedman on behalf of military installations in California in opposition. We've worked with the Coastal Commission staff on revised language.
Thank you.
Good afternoon. Ken DeWorth, the National Federation of Independent Business on behalf of small businesses. We oppose.
Aaron Guerrero on behalf of California Building Industry Association in opposition.
Matthew Hargrove on behalf of BOMA California, NAAP California, and ICSC in opposition.
Thank you. Questions, comments from the committee? Mr. Harper.
Thank you very much. One of the bills that came through this committee back in April was from one of our colleagues from Santa Cruz regarding ex parte communications and regulation thereof. Do you have any comments as to how your bill is different than that one or why it should be passed over that one?
I'm afraid I don't have any specific recollection of that bill. I apologize.
He's referring to the Stone bill on ex parte communications, I believe.
2002, AB 2002.
Oh, this was a bill that required people to register as lobbyists? Mm-hmm. I support that bill. I think that that's important, but that doesn't go to the question of whether or not people should be able to have ex parte communications, whether they're lobbyists or not. But this is a bill that addresses maintaining, if you will, a level playing field so that we prohibit ex parte communication so that one side doesn't have unfair advantage, one commissioner doesn't have greater influence and information than other commissioners or different information, so that we end up having this battle of who has access to whether it's better information, different information, more information, less information. The goal is that everybody has the same information and can ask questions based upon that information, which will then result in whatever decision that commissioner determines to make.
Well, you have commissioners that are appointed, by the state, and some that are bottom up that represent particular areas of the state of California. With the commission moving from location to location, they don't meet like we do here in the state capitol. Sometimes they're in Huntington Beach, sometimes they're in Long Beach, sometimes they're much further north and out of reach of folks. Isn't a part of having those regional representatives for them to be able to be more accessible to people who are closer to their area, just like we are more accessible to those in our districts?
Do you want to answer that?
While it's true that commissioners are appointed from specific locations, once they're on the commission, their job is to represent all of the coast. They're not there to specifically represent a section of the coast. And that's one of the reasons why the commission moves up and down the coast. As far as the Bill 2002, okay, there's no inconsistencies between those bills. They deal with different things, and they can easily be reconciled. This deals with one type of ex parte. There's still other types of ex parte communications and communications that can take place. Adjudicative will be prohibited, but the other functions of the commission, which are non-adjudicative, will still be able to allow ex parte communications to take place. So there is a big difference between this and the way the legislature deals with issues which are legislative, and the way commissioners who are supposed to represent the entire coast once they're on the commission. They are not representing a particular locality.
Well, thank you, Mr. Chair. When I served on the school board, city council, and here, I find ex parte communications very valuable to my job to be able to listen to what constituents want from me, and I think that this bill would probably have a chilling effect on that kind of communication to members of the Coastal Commission.
Other comments or questions from the committee? Mr. Hadley.
Thank you, Mr. Chair. Senator, I'm not going to ask about the ex parte communications. I'm more interested in something you said early in your testimony and in the bill, in terms of the relationship between the commissioners and the staff. You were holding out. I don't want to put words in your mouth, but you were holding out the notion that the staff should be completely independent of the commissioners, if I understood you correctly. And if I were a commissioner and I were given a report by the staff and I said, I'd like to know more about this, or have you thought about it from this angle? Have you studied it from that standpoint? As I read Section 2 of this bill, I'm using the influence of my office to affect a staff report. I just want to make sure I understand what you have in mind about the relationship between the staff and the commissioners.
Well, the staff's job is to be the experts on the subject and to make an independent determination based upon their responsibilities to uphold the integrity of the Coastal Act and its requirements, so that the decision making, so that their report demonstrates or is sort of a fact finding. So if you're a commissioner and you say to a staff, would you provide more information on this particular subject? That's a totally appropriate inquiry, and one that I would expect that the staff would follow up on. But to say to the staff, I don't like this finding that you've made, change the finding. I think, is the place where we're talking about the independence, the importance of the staff to provide its best professional determinations, which they then put very specifically in a report. They articulate why they've come to that conclusion, and that is the information that goes to the commissioners, who then, based upon that information, make a determination in a public proceeding.
Can I add to that? As a commissioner, this bill does not in any way prohibit you from talking to staff, from asking questions to staff, or even giving information to staff. There's a big difference between that. Let me read the section. This section shall not be construed to prohibit a commissioner or alternate from communicating with or providing information to commission staff members about matters before the commission. So it's very specifically dealt with in the bill to make it clear that it does not prohibit commissioners from having discussions. But there is a big difference between discussions and telling somebody, particularly when you have 12 different commissioners, okay, from them starting to tell the staff and direct the staff how to write their and what to say, particularly in technical reports from like geologists or in other scientists. So I think that is what the intent of the legislation is about.
Other questions, comments from the committee? I also, yes.
Sorry, Mr. Chair. Senator, a couple of concerns. It's kind of dovetailing a little bit on the witnesses' comments regarding the coastal commissioners coming from different areas but representing the entire coast. So a couple of concerns from constituents, in particular the Environmental Center of San Diego, notes that they appreciate that there's a San Diego representative, as I'm sure that the rest of the state appreciates their local representative commissioner. And there's a concern here that now they will no longer be able to communicate directly with that commissioner because they're not able to go to all of the meetings around the state. And this bill would specifically preclude, well, I'll put it in quote, losing the ability to hold ex parte meetings with our local commissioners will severely limit our ability to protect our coast. And kind of along that same line, the Coastal Commission meetings, not only will they now be more difficult to speak to because not everybody can get to them, but if you do get there, they limit the amount of time, just as we do here, the amount of testimony that you can present to the commission while you're there presenting to them. So if it's limited to 2 minutes, which I understand is often the case, or a few minutes, it's impossible at that point in time to fully communicate your interest as a constituent and as you stated in your opening statement, being responsive to the will of the people.
Well, you can talk to the staff. There's no problem having the opportunity to do that, no matter where you are in the state. And certainly environmental groups have a particular public interest, if you will, in the areas in which they practice law or seek to protect an area. No problem talking to the staff on those issues. No problem of writing a letter either, of submitting a report, or of doing any of those things. The issue here is giving somebody the opportunity to have a one-on-one conversation with the decision maker to the detriment of the other side, to the detriment of those who might either support a measure or oppose a development. I mean, the fact is it creates an unlevel playing field no matter where it comes from. The staff is available to talk to anyone and everyone, and they will most likely put in their report as they do their analyses that the environmental group in San Diego says X, Y, and Z will happen. They provided us information for it. We looked at that information. We agreed with it or we disagreed with it based upon the following. And it's information that goes out to the whole adjudicatory body. It goes out in their report to all of the commissioners, so everybody has the same information and can make a determination based upon that information.
Senator, I strongly disagree with that statement that they can come and talk to. I mean, I agree with the statement that they can come and talk to the staff. That's absolutely accurate and true, and and should take place as well. But what I strongly disagree with is that they don't have access to the commissioner that's actually making the decision and coming from local government as a city council member, making decisions on these same, similar type matters. It's very important that the person making the decision be able to hear from both sides of the issue. I don't think eliminating ex parte communications is giving the status quo. I don't believe gives one side an advantage over the other side. They both have currently equal access if they want to take advantage of those opportunities to the commissioners. As a city council member making a decision in similar to this, you have to be able to talk to the stakeholders on both sides of the issue to come to a conclusion. If you're eliminating the commissioner's ability to have access to the stakeholders, why don't you just eliminate the commission and just have a staff-run operation and not have commissioners?
Because this is a
rhetorical question.
It's
not entirely rhetorical because
it is. You have
several comments. There's been several statements from the witnesses and the author today that they want to eliminate access to the commissioners and that the staff is the experts. The staff are the ones that are doing everything. And I agree. The staff work hard at the Coastal Commission. This is not a criticism of the staff. There's a criticism particularly of this bill. And I just, that's where these comments have gone today, and I wanted to bring it to light that that's kind of the attitude that's coming out on that.
Senator, I hope you'll give the chair the prerogative to maybe answer this. In my view, look, it boils down to me. I would prefer that everybody get as much access to folks as possible, but it boils down to me that is a logistical impossibility for the commission. This is as if you represented, as a part-time council member, you represented a council district with more than 40 million people. In that scenario, it is impossible to provide equal access to all stakeholders. So what happens in practice is that the big developer's lawyer gets more access than the chapter of Surfrider Foundation from a little town of 10,000 people. That's just the way it happens in reality. And unequal access to government, in my view, is a problem. And that's why I, as chair, believe that we should support this. It is just simply a logistical impossibility for a bunch of part-time legislators, essentially, to provide equal access to over 40 million people. And I can tell you that the confidence of people in much of the coastal communities of the state in the Commission's ability to impartially render decision-making have been severely weakened, and this legislation would improve it.
May I continue
Yes.
my time? Thank you, Mr. Chair. I just want to point out that the Environmental Center of San Diego is not a big, high-powered attorney that can do whatever they want. They have legitimate concerns that their access to their local commissioners is going to be limited. The United Association of Local Union 345 opposes this. The United States Navy has challenges with this bill. I just feel like we are eliminating a good role of governance in the way it's run now, and I don't think this goes to solving it. Thank you.
Other questions, comments from the committee? I think I've explained why the chair's recommendation is aye. Would you like to close?
I would. And I would like to remind everyone that there is a difference between a city council, which is a legislative body, and the Coastal Commission when it is acting as a quasi-judicial body. And that is the distinction. And that is the distinction. Again, this is a question of balance. It is a question of fairness. Why should one party have a leg up over another when it comes to development along the coast? And that is the question. That's why we have a Coastal Commission. That's why the Coastal Act was passed by the overwhelming voice of the people. That's why we have a Coastal commission staff with the responsibilities of determining whether a development is consistent with the Coastal Act and is sustainable. And that is why there has been such extreme concern. I wouldn't call it hysteria. In fact, to the contrary, it was indignation, knowing, having exposed the fact that developers particularly are able to access coastal commissioners on a one-on-one basis without any opportunity for the opposition to A, participate, B, know what's being discussed, or C, being able to respond to what's being discussed. This is a bill that restores confidence in government through transparency, and it was mentioned, this is the only agency, the only quasi-judicial body in the state that allows for these ex parte proceedings. That is, I think, been a mistake. I don't think that's what was originally intended. Well, I believe you got a letter from then Assembly Member Terry Friedman, whose bill it was that was referenced here. It was never the intent to allow these kinds of ex parte communications. We've seen what happens when they do exist. They're inappropriate, they're improper. This is a bill that tries to correct that mistake and put everybody back on the same level playing field. With that, I would ask for your aye vote.
Please call the roll. Oh, there has not been a motion. Can I get a motion? Motion by McCarty, second by Wood. Please call the roll.
The motion is due pass and we refer to appropriations. Williams?
Aye.
Williams, aye. Jones?
No.
Jones, no. Garcia? Garcia, aye. Gomez? Hadley?
No.
Hadley, no. Harper?
No.
Harper, no. McCarty? McCarty, aye. Stone? Wood? Wood, aye.
That is 4-3. We will leave that on a call as long as it takes, Senator, and we will take Senator Morlock.
Thank you very much, Mr. Chair and members.